Hello, today we talk about patent pathways for your startup. This is a guide to building intellectual property portfolio that can help you in fundraising as well as in the marketplace. So what is intellectual property? It's a system that was enshrined in our Constitution to protect inventors as well as businesses from copying. There are 4 types of IP assets. There are patents, which protect inventions, trademarks, which protect marks and branding. There's copyright system, which protects musical scores, written works, websites, etc. And there are trade secrets, or items of importance to your business that you've taken care to keep as a secret. Next, we will discuss the importance of IP for startups. First, IP provides a competitive advantage for businesses because it provides you with a protective barrier, a moat as they call it. For a startup company, IP give you breathing room so that you can innovate safely without being copied by giant competitors in your space. It also attracts investors because investors think that a company with protectable, defensible IP space would be safer than a company without. And it also increases company valuation for 2 reasons. First, the IP are assets that are shown up in your balance sheet. Second is that it enables you to charge more for a premium product. And because of that, you would have a higher net profit. And that higher net profit projected over time enables a company valuation to be increased. So IP increases valuation in 2 ways. As actual assets in your balance sheet and also increasing the cash flow, which increases the overall company valuation. Let's now discuss the patent system, which is the most powerful because patents can block an entire space if you happen to be the first company in that space. There are 3 types of patents. There are utility patents. Software would fall into utility patents. Medical devices would fall into that. Chemical inventions would be utility. And also mechanical inventions. AI would be protected as a utility patent application as well. There are design patents which cover the look and feel of a device. An example might be the Coke bottle. There are also plant patents covering various species of plants. Software would fall into utility patents. So what are requirements for getting a patent? First of all, there has to be novelty. And by novelty, we mean that hadn't been done before. Exactly the same thing hadn't been done before. It has to be non-obvious. So if you invented a car and somebody else tried to patent a green car, well, that wouldn't be a non-obvious unless somehow you can show that green somehow enables a car to operate 10 times more efficiently, providing amazing results that are just unexpected. Then that may be patentable. And it has to be a useful invention. So that one is a pretty easy threshold. It can't be for, let's say, an immoral purpose that would not be useful in the patent office's eye. So let's discuss the process for applying for a patent. In general, people recommend that you do a patent search. And we can do this formally using a patent search specialist firm, or you can, on your own, go to the US Patent Office and do a search on your invention. Anything that's within the past 18 months wouldn't be in the patent literature. So you might want to supplement that with a, let's say, a non-patent literature search. My approach is to do some initial patent search just to satisfy yourself that the field is clear, but then focus more on preparing the patent application by providing as much details in it as possible. And the reason for that is, let's say, you invented something here and somebody in Russia work on the same problem. What's the probability that you are going to implement your invention and they are going to implement their invention exactly in the same way? You each are going to have your own spin on how you solve the problem. And because of that, as long as you provide details on what you do, then you can always differentiate from what the other inventor in Russia is doing. That's the best you can do because no matter what you do, the inventor in Russia is going to invent on his own. So the question then is, okay, if there is a race to a particular patent, who would win? Well, if you've done your best and provide as much of a detailed disclosure, you can find a way to differentiate the claims and convince the examiner that your particular invention is novel given the prior art. So that's what I mean by providing as much details into the application. Another angle to do is to provide as many drawings as you can in the patent application. And why is that? A picture is worth 1,000 words. So the more drawings you have, the more you can describe in the application, and in case something that was inadvertently left out, you can always point to the picture and say, hey, the figure shows this way, even though we didn't expressly state it in text form. So drawings, detailed drawings, can serve as a type of defensive barrier in case you run into some unexpected prior art that you need to go in and differentiate the invention, and your text somehow doesn't have that. The application has to be prepared in a particular format with a particular style specified in the manual patent examination procedure. It's a long, thick document, so patent lawyers are there to help guide you through the process. When you file the case, if you do a non-provisional, it will sit there for about 18 months to about 2 years, and then it will be picked up for examination. So you got a long lag there. Once it's examined, the examiner will review the application for formality compliance and test your invention for novelty, obviousness, and in case of software, patentable subject matter issues, and also, whether or not you have support for your claims in the description, call it 112. Typically, we commonly see 112 rejections, meaning the claims are informal and we need to tweak that. Then sometimes we'll see a 102 rejection, which is a novelty rejection. In a 102 rejection, you've got to identically match the claim, the prior art to the claim. And so it's less common. More common is an obviousness rejection, where the examiner will say, your invention is obvious in view of 2 to 3 patents that are in the space, and each of them don't quite have all the features to be a novelty rejection to you, but they're close enough and they have enough of the pieces in there that somebody's skill can piece them together and come up with your invention. The way we would normally push back on that is combining that. It wouldn't quite work, because it's like combining a jet airplane with a helicopter. They're both they're both flying vehicles, but combining them wouldn't make any sense. So that's one common way of traversing the rejection. You go through this cycle until you either convince the examiner that your invention is novel and then it's allowed, or if you can't, the examiner will do a final rejection, and then you have to appeal or pay another fee to keep on the examination discussion. So the patent strategy for startup is that you should have this embedded in your startup early on. Have a culture that thinks about IP protection, because IP patents, for example, would be a tangible asset that you can increase your company valuation. When to file a patent? You should file a patent as soon as possible, because those who file first will get all the benefit than the company that files second. So therefore, speed is essential. You should have that embedded, baked into your system, that before you launch a new product release, you should go through and review if there's any new novel items that you should patent, and then you build your portfolio that way. If you are investing in the stock market, you wouldn't bet all your investment into just one stock, right? You would spread them out, and that spreading it out is basically called diversification. So you would apply the same strategy, the diversification strategy, for your stock portfolio as in your IP portfolio. Provisional versus non-provisional patent application. A provisional application is great for establishing early priority if you just started out and you're pivoting your product concepts. In that case, if you have uncertainties, provisionals are great. The other proper use of provisional is to extend the life of your IP, and the drug companies are perfect at this. What they do is for a new drug that comes onto the market, they file everything as a provisional, but that provisional is written as though it was a full-blown application. A year from now, they convert that provisional into a non-provisional. And what's the advantage of that approach? So if you stack the provisional and a non-provisional together, you gain 21 years of life for your patent. And for the drugs industry, every extra year of life is worth billions. So that's another way of using provisional. Now, if you're in the software space, using the provisional approach may or may not work well, because software advances so fast, and by the time the patent application pops out, it may be old. But even at that, it will have value because it captures the technology as of that time frame and is valuable for licensing. It may no longer protect your product, but it's good for licensing purposes. Let's talk about international patent protection. Within 1 year of filing the first application, be it a provisional or non-provisional, you need to convert that into international cases in case you want international rights. At the end of that 1 year, convert and file everywhere globally, and you would do this by doing the translation, and then you would then directly file in each national offices. The problem with that is very expensive to do all the translation and then the filing costs. The governments of the world have signed what is called a Patent Cooperation Treaty, or a PCT. And what happened there is within 1 year, instead of filing on all individual countries, you can file a PCT patent application. And it serves to extend your timeline to go national into each office by an additional 30 months to descend into the individual national countries. There's a cost associated with a PCT, but think of it as a budgeting mechanism where at the end of the 1 year period, you're going to pay, let's say, $5,000-$6,000 for a PCT application, but that defers the hundreds of thousands of dollars that you're going to have to spend going national everywhere by a total of 30 months from the very first filing. So many startup companies use the PCT procedure to defer that ultimate cost. And they hope that by then either they have significant sales or they have raised big amount of money, and then the PCT cost is really just a financing factor. You're paying for the delaying of the cost of going national at the 1 year period, particularly since you might not know if you might need to pivot, for example. So that time delay is useful. When managing patent cost, I think one thing you need to look at is the lawyers that you work with. If you use a big firm, typically they have big clients, and that means that they're going to put their best people to serve the big client who gives them chunks of work every month. You as a startup would be lower on the totem, and you would probably be assigned a junior attorney. You'll be paying for her learning curve. You may want to go and work with a boutique patent firm that values your business. And so work with the smaller firms that have the right technology expertise as well as the expertise of navigating through the patent office, and that's how you're going to save money. You can also consider the use of AI tools to create the first draft. There are tools such as Power Patent that will do this for you, and then you give it to the lawyer, clean it up, and then they file it for you at an overall lower cost, and that results in time saving as well as money savings. And that's a high-level picture of how a startup can obtain and build a patent portfolio in a very cost-effective and high-quality manner. If you have any questions, please visit patentpc.com. Thank you.